This podcast contains descriptions of violence against children and adult language and is not suitable for all audiences. Listener discretion is advised. Hi everyone, and welcome to Suffer the Little Children, the true crime podcast giving voices back to the victims of child abuse and shining a harsh spotlight on the parents, guardians, and caretakers who silence them. I'm your host, Laine, and this is episode 133, Case Update Special number 9. Like I did last week, in this episode, I will provide updates on some of the cases I've covered in early episodes of the podcast. The cases discussed in today's episode include those of AJ Freund, Treyanna Summerville, Sereniti Sutley, Josias Marquez, and Conner and Brinley Snyder, as well as another quick update in the case of Arabella Parker. This is episode 133, Case Update Special number 9. I'd like to give a special shout out to my newest patron, Norina M. from St. John's, Michigan. Thank you so much for your support, Norina. My patrons are a large part of the reason I'm able to work from home, which means I can continue making this podcast, so I appreciate all of you more than I can tell you. If you'd like to contribute to the show, you can make a pledge at patreon.com/stlcpod or a one-time contribution at ko-fi.com/stlcpod. Thank you to all of my listeners. Because I've covered so many ongoing cases since the show began in February of 2020, I plan to sprinkle more of these update episodes throughout the next several weeks, but not necessarily back to back. On that note, I'll get right into today's updates. In my first ever post on Suffer the Little Children blog, and the first episode of this podcast, I told you about 5-year-old AJ Freund. AJ was a spirited, smart, caring 5-year-old who loved being read to, putting puzzles together, playing with toy trucks and other heavy machinery, Thomas the Train, and Teenage Mutant Ninja Turtles. In April of 2019, Andrew Drew Freund Sr. and Joanne Cunningham reported their 5-year-old son missing from their filthy, dilapidated, severely hoarded home in Crystal Lake, Illinois. Within days, information they provided to police led to the discovery of AJ's body buried just miles away in a shallow grave, wrapped in garbage bags. Both Drew and Joanne were arrested and charged with AJ's murder. In December of 2019, Joanne pleaded guilty to first-degree murder, avoiding a life sentence. At her sentencing hearing in July of 2020, a tsunami of evidence of Joanne's guilt was presented by the prosecution. Still, Joanne, who was indisputably the person who physically caused AJ's death by beating him savagely with a shower head and causing his brain to swell to the point of herniation, was sentenced to a paltry 35 years in prison. In September of 2020, Drew pleaded guilty to aggravated battery of a child, involuntary manslaughter, and concealment of a homicidal death. He was sentenced to 30 years for his part in AJ's death, namely allowing his wife's chronic abuse and ultimate murder of their young son and then concealing his body. 2 former employees of the Illinois Department of Children and Family Services, 55-year-old Carlos Acosta and 49-year-old Andrew Polovin, were arrested in September of 2020 and charged with 2 felony counts of endangering the life of a child and 1 felony count of reckless conduct for their inadequate, negligent handling of AJ's case. Because of government immunity, this is one of the only cases I've ever covered or even seen in which anyone involved with Child Protective Services have faced criminal charges for their negligent conduct. Their cases are ongoing, and that's where we find one of the updates in AJ's story. Last year, the prosecution moved to admit 19 police reports into evidence that they say DCFS employees didn't bother to request during their investigation into whether AJ was being abused. According to Assistant State's Attorney Ashley Ramito, the police reports document the family's history of domestic violence, mental illness, theft, drug abuse, and other crimes. By failing to request the reports, which a reasonable DCFS worker would, the prosecutor said, Acosta and Polovin put AJ in dangerous circumstances that led to his torture and murder some months later. In December of 2022, Judge George D. Strickland granted the prosecutor's motion to admit the 19 police reports into evidence. It still hasn't been determined if Acosta and Polovin will be tried together or separately, or whether each will opt for a bench or a jury trial. In August of 2022, I combined all of my coverage of AJ's case, as well as a couple additional updates, into episode 123, AJ Freund Mega Episode. Joanne, who will turn 40 in prison at the end of this month, is serving her sentence in the Logan Correctional Center in Lincoln, Illinois. Her projected discharge date is currently listed as April 24, 2054. 64-year-old Drew is incarcerated in the Hill Correctional Center in Galesburg, Illinois. He may be paroled as soon as February 26, 2038. Episode 20 featured the story of 18-year-old Treyanna Summerville. Treyanna was a smart, dedicated high school student and gifted track athlete who loved cheesecake. On June 22, 2020, Treyanna died in the Gouverneur, New York home she shared with her mother, younger sister, and stepfather, who was deployed in South Korea at the time. Initially, Treyanna's 13-year-old sister was arrested and charged with her murder. Less than a month later, Treyanna's mother, LaShawna Charlton, who had an extensive history of child abuse and CPS involvement, was also arrested and charged with second-degree manslaughter. She was quickly released on a $50,000 bond. In September of 2021, the charge against Treyanna's younger sister was finally dropped, and her mother was indicted later the same month. In October, LaShawna pleaded not guilty to 4 counts of second-degree murder, first-degree manslaughter, and endangering the welfare of a minor, the last relating to Treyanna's younger sister. LaShawna was accused of hitting Treyanna with a hammer and subsequently failing to feed her or obtain medical assistance for her wounded daughter. LaShawna's lack of care for Treyanna led to a severe septic infection, which, along with malnutrition, caused Treyanna's death. Treyanna also suffered from drug intoxication after her mother gave her large doses of diphenhydramine, which is the active ingredient in Benadryl and has well-known sedative properties. I last updated Treyanna's case in episode 89, which I released in November of 2021. After that update, LaShawna's jury trial in St. Lawrence County Court was scheduled to begin on October 11, 2022. That, however, was postponed, and around the same time, news broke that LaShawna was scheduled to plead guilty the following month. St. Lawrence County District Attorney Gary Pasqua declined to comment, telling the Watertown Daily News, "I don't discuss pleas or plea offers." After a short delay, as expected, on Monday, December 5, 2022, LaShawna appeared in court, where she pleaded guilty to first-degree manslaughter. According to 7 News, LaShawna shielded her face from news cameras with paperwork as she walked out of court following the hearing. Mr. Pasqua announced, "She entered a plea of guilty to manslaughter in the first degree in the death of Treyanna Summerville that was in satisfaction of the entire indictment pending against her, satisfied all the charges, including the charges against the second victim, for endangering the welfare of a child. It's also important to remember we had a second victim in this matter. I needed to not only get justice for Treyanna, but I also had to get justice for that victim, and justice for that victim looks a lot different than what justice for Treyanna looks like." That justice came on Monday, February 6, 2023, when LaShawna Charlton was sentenced to 20 years in prison, followed by 5 years of supervision. Her younger daughter, who is now 15 or 16, was granted an order of protection against LaShawna. According to Mr. Pasqua, "Many people failed Treyanna during her life. They are not necessarily responsible for what happened to her. Miss Charlton is, but the fact still remains that there were opportunities to intercede and for someone to step in and care for her." In a statement after the sentencing, the district attorney said, "Today is ultimately about justice for Treyanna and the other victim in this case. That brave survivor gave a heartbreaking and powerful statement to the court, and it's important to note that both victims suffered years of abuse and neglect at the hands of the defendant. Treyanna's death was tragic. This was a loss that no amount of time can provide solace. Treyanna will never get to live a normal life and experience the milestones that we all look forward to: graduations, falling in love, raising our children. Treyanna spent much of her short life trying to protect her sibling. Unfortunately, that protection only comes now because Treyanna lost her life. This sentence will hopefully allow the family to heal and allow the survivor a chance to be nurtured and cared for in the loving environment she deserves. She now has the protection Treyanna desperately wanted for her, as the defendant serves a lengthy sentence as punishment for her actions. That is justice for both of them. 41-year-old LaShawna Nicole Charlton was transferred on Monday, February 13, 2023, from the St. Lawrence County Jail into the custody of the New York State Department of Corrections and Community Supervision. At the time of this recording, it's still not clear which prison facility she will be taken into. Just one small footnote to this tragic story. I've received emails and comments in various places from people purporting to be family members of Treyanna's, and posts containing similar information were made by an unknown source in the Justice for Treyanna Summerville Facebook group, although those posts were later deleted by group admins. I believe I received these messages because I mentioned Treyanna's brother Isaiah's involvement in the media coverage after Treyanna's death. In these emails, comments, and posts, these individuals claimed that Treyanna's older stepbrother, Tavon Isaiah Samuels Charlton, who went by simply Isaiah Samuels at the time of Treyanna's death, was misrepresenting himself throughout the case as her loving, protective brother, when in truth, he was also abusive to her. I'll read excerpts from the allegations in one such message. The brother forgot to tell everyone that he was kicked out of the home for abusing Treyanna as well. Tavon Charlton Samuels, a.k.a. Vonzea Samuels, a.k.a. Isaiah Samuels, or whatever name he uses to hide behind, failed to share 2 cases that he assaulted and bruised Treyanna. He has lied and even tried to profit from her death as Treyanna's actual family and friends shut down GoFundMe-type pages he tried to be a part of. He doesn't know Trey and never had a relationship with his younger sister. He also disrespected Treyanna's family at one funeral and was blocked from attending the second funeral. Tavon is upsetting his sister, and before he wants to deny it, Treyanna's father actually is aware, since CPS in those incidents had to contact him about it. No family associates with him, and he is not a credible source to even speak on anything in that house. The family is trying to pick up the pieces, and this guy has participated in vigils and protests, knowing full well that he was disowned years ago. Tavon thinks as long as he doesn't tell everyone he can continue on like this. He has lied and continues to upset the family, and we have sat back too long, watching him act like an authority on the matter. So if you want justice for Trey, you should include all problem parties. He burned all bridges and can't even tell accurate facts about the sister he claimed to care about so much. We are tired. Treyanna's real family is tired of him and his lies. This has been taxing on our family, and stop using him as a credible source. Just for the record, I don't know if there's any truth to these allegations. I never spoke with Isaiah or any member of Treyanna's family myself, but I did quote his statements as printed by local media sources in the original episode. Interestingly, Isaiah was charged in July of 2021 with first-degree burglary after brandishing a machete during a domestic incident in an Ogdensburg, New York home. The judge issued a no-contact order of protection to the victim in that case. I've been unable to find any update on that since the initial news article. No matter what, I just hope Treyanna's younger sister is doing well. She's been through an unthinkable trauma, and I hope she gets the love and support she needs to work through it all. I wish her nothing but the best in the future. I'll pause here for a quick sponsor break. The next case I'll update today is that of 1-year-old Sereniti Sutley, whose story I told in episode 21 of the podcast. If you follow me on Facebook, you likely already know how strongly I feel about this case. On September 13, 2017, Sereniti Jaslyn Sky Blankenship Sutley, a beautiful cherub of a baby with wispy blonde hair and big blue eyes, celebrated her first and only birthday. Less than a month later, on October 7, 2017, Sereniti's mother, 22-year-old Kelsey Blankenship, found her daughter's lifeless body in her crib in their Conneaut, Ohio apartment. Several hours later, Sereniti was pronounced dead in the hospital. An autopsy indicated that Sereniti was raped and badly beaten. Her death was caused by blunt force trauma to the head and trunk. Kelsey's boyfriend, 37-year-old Joshua Gurdo, was questioned and released. He immediately fled the state of Ohio, leading police on a 3-week manhunt. He was finally captured at a gas station in Pennsylvania, facing multiple charges, including 3 counts of murder, 2 counts of aggravated murder, and 1 count each of felony rape, felonious assault, and misdemeanor domestic violence. A year later, Kelsey was also arrested and charged with 2 counts of felony murder, 1 count of felonious assault, 2 second-degree felony counts of endangering children, 1 third-degree felony count of endangering children, and a misdemeanor count of domestic violence. In December of 2020, Joshua was also indicted on multiple charges relating to a 2004 rape and burglary. In March of 2021, Kelsey accepted a plea agreement, pleading guilty to reduced charges of involuntary manslaughter and third-degree felony child endangerment in exchange for a 6-year prison sentence, less time served. She is currently serving her sentence in the Ohio Reformatory for Women in Marysville, Ohio. She will be eligible for parole in October of 2024. In October of 2021, the new Ashtabula County prosecutor, Colleen O'Toole, offered Joshua a plea deal, which enraged me and everyone else who had been following this case. Shortly afterward, Judge Marianne Cezanne denied the prosecution's motion for a plea deal, which led to Ms. O'Toole filing for the judge's recusal. Judge Cezanne ended up recusing herself from Sereniti's case and was replaced in March of 2022 by retired Judge Patricia Cosgrove. In May of 2022, Joshua Gurdo was sentenced to 28 years in prison for the 2004 burglary and rape case. Brace yourselves, and I'm sorry in advance because that's the best news you're going to get in this story. If you listen to episode 122, Sereniti Deserves Justice, you know that in August of 2022, I spoke with Sereniti's great-aunt, Bobby Blankenship, Grandma, Melissa Sutley, and Dad, Brandon Sutley, about recent developments in Sereniti's case. The previous month, Ms. O'Toole filed another abominable motion with the court, this one to dismiss 6 of the 8 charges against Joshua Gurdo, and to reduce his remaining murder charge to one of involuntary manslaughter. Needless to say, Sereniti's family, as well as the citizens of Ashtabula County, Ohio, and anyone else who followed Sereniti's case, were disgusted by the prosecutor's unwillingness to follow through with prosecuting the man charged with this baby's rape and murder. Through multiple social media posts, I didn't make my disdain for Miss O'Toole a secret, and I have a feeling she's not exactly a fan of the podcast, but I literally couldn't care less if I tried. Shortly after I released episode 122, Ms. O'Toole responded to public criticism about her actions. Her lengthy letter of response, in which she infuriatingly refused to refer to Sereniti by name, was published in the Gazette News, reading, "The position of the prosecutor regarding the case of State v. Gurdo and the tragic death of SJS. Sadly, there is nothing I or anyone else can do to bring this child back. This cold, hard fact weighs heavily on the diligent prosecutors and me in the performance of our duties every day. With every tragic case, I share the pain, anger, and confusion with victims, but especially with the sad death of this child with the family, the newspapers, and the public. This poor defenseless infant was, for the duration of her short 13-month life, in and out of the custody of her suicidal, mentally ill mother and other caretakers. They, for apparent reasons, could not care for her and keep her safe. The facts that surround this case, many of which are under seal, and which ultimately led to my decision to amend and dismiss some charges in favor of others, are supported by the evidence, yet to be proven in court. However, the facts and specifics are prohibited from being disclosed, based on a judge's prior order, until the case is concluded. These facts and the tragic death, which will be public record, occurred almost 5 years ago. I came upon this case after it had been pending for over 4 years. Therefore, I urge citizens to reserve judgment on the wisdom of my decision until all the facts are known. The Constitution binds us and our oath to do justice, pursue cases independently, and follow them where the evidence leads, regardless of the outcome. We do not prosecute to seek revenge, vengeance, or political advantage, nor allow our decisions to be swayed by angry mobs or internet trolls. My office is dedicated to serving justice and doing the right thing, even when the public disagrees. I believe that we must all accept the legal requirements of the rule of law and the Constitution. My responsibility includes resolving this matter as quickly and fairly as possible, a task that eluded the prior prosecutors and judges in this matter. This case has been continued or reset 22 times. I have attempted to resolve the issue on numerous occasions, including petitioning the Supreme Court to recuse the existing judge to expedite the case after it had been pending for over 4 years. Mr. Gurdo was accused of another crime of rape. Also, before my arrival, he pleaded to the indictment, and the new judge sentenced him to 28 years of incarceration. It is my job to be the cleanup crew, make the hard calls according to law, and get this case concluded in the fairest way for all concerned, given the limitations of my authority. I understand the outrage, given the limited information available to the public. Here are some answers to some questions posed by the articles. Is the prosecutor doing her job or taking the easy way out by dismissing the charges? This case is complicated, and there are multiple parties responsible. As mentioned before, the prior prosecutors could not conclude this case for various reasons. The charges, as amended, conform to the evidence and what can be proven beyond a reasonable doubt, and the offer is what the evidence will prove beyond a reasonable doubt at trial. There is no easy way out of this case. My goal is to prosecute the case cleanly and within the bounds of the law. Why has this case taken so long? The judge is the one who controls the docket, not the prosecutor. COVID played a big part. Once this case is resolved, the records will be opened. They are currently sealed as a result of a judicial order. This prevents the public from looking at documents about this case, thus getting the whole picture. Additionally, it prevents me from speaking about any of these documents. The judicial order was set in place by a judge who let the issue languish for years without bringing the matter to trial. Justice delayed is justice denied. Since assuming office, I have worked with the courts to resolve their slow and non-conforming dockets. This is an ongoing project. The judge, the defense, and prior prosecutors have continued or filed 22 times. Yet, since taking office, my office has not filed for any continuances. How do you define justice for SJS? This case isn't as simple as laying blame on one or two individuals. The death of this child lay in a series of misjudgments, errors, and actions by multiple individuals and organizations that were charged with keeping the child safe or diagnosing her appropriately. I feel that justice shall not be done until there is a deep dive into the failures that allowed this child to essentially be neglected from the beginning of her life until the tragic end. The decisions which allowed this child to be taken and returned to the care of her suicidal, mentally ill mother and her boyfriend. This child was left in the care of two people who were not competent to care for themselves, let alone have care of a child of this tender age. Addressing and resolving these broader issues will be my focus once this case is concluded. We must correct these errors and prevent them from reoccurring with other children. Preventing this situation from recurring is a big part of how I define justice for every victim, including this one, and what I have been continuously working towards. Thank you for your attention. The way Ms. O'Toole blamed Judge Cezanne for the delays in the case and not the vast number of motions filed by the defense was reprehensible, and there's no question in my mind that those delays had nothing to do with Ms. O'Toole's reason for filing to recuse the judge. That filing was, in my opinion, 100% petty revenge for the judge's denial of her motion for a plea deal. As of today, I still have yet to see any proof that Ms. O'Toole was justified in reducing the charges. Despite Ms. O'Toole's attempt at damage control, protesters rallied outside her office, demanding justice for Sereniti and imploring her to do her job. Listener Sophie provided me with a transcript of a statement former prosecutor Cecilia Cooper issued in response to Ms. O'Toole's printed excuses. Ms. Cooper's statement was even longer than Ms. O'Toole's, but it's extremely powerful and insightful, and worth quoting in its entirety. This letter is in response to the press release from Colleen O'Toole dated July 29, 2022. There have been many things that have occurred in the prosecutor's office since Ms. O'Toole took over from me that I would like to have commented on, but I have held my tongue, as the saying goes. I am sure there are many things Judge Iarocci would also like to say, but he is bound by the Judicial Code of Ethics to remain silent. I am not. As one of the former prosecutors Ms. O'Toole now blames for the proposed resolution of the Joshua Gurdo case, I feel compelled to respond. First, and most importantly, Sereniti Sutley was a beautiful little girl who deserved a long life filled with smiles and joy. She was much loved by her extended family and friends who were like family. There were people in her life who did step up and love her and try to take care of her, but there's only so much family and friends can do. It is not her extended family's and friends' fault Sereniti is dead. She was murdered. To say otherwise is an abomination. The deepest sympathy of the two prior county prosecutors who worked this case has always been and continues to be with those who loved Sereniti and who tried the best they knew how to protect her. Second, it is disingenuous to blame prior administrations and the courts for the length of time it has taken this matter to go to trial. What's worse is using the delay as her excuse for not aggressively prosecuting Joshua Gurdo as she said she would when Kelsey Blankenship, the, according to Ms. O'Toole's press release, suicidal mentally ill mother, was offered her sweetheart deal. Do you want to know the real reason Gurdo's murder trial had to be continued so many times? Kelsey Blankenship. As anyone who has read anything about this case in the paper could guess, the mother who found Sereniti unresponsive, Kelsey Blankenship, is an essential witness in the trial of Joshua Gurdo. However, Blankenship, as a person charged with a crime in connection with Sereniti's murder, had a right to remain silent while her criminal case was being vigorously pursued under Mr. Iarocci's administration and my administration. There were several times the Gurdo trial had to be continued for this very reason. A review of the public docket will prove it took 3 years to resolve the Blankenship case, not because of the state or the court, but because of the zealous defense she was given by her attorneys. This is their job, to fight for their clients. There were many times motions were filed by the defense that had to be considered and ruled on by the court. There was even an appeal that took months to be heard by the Court of Appeals. All of these motions and the appeal by rule of law stopped the trial from going forward. The motions were heard and the appeal was ruled on, and the trial was finally set for May 19, 2020. Subpoenas were issued and the state was preparing to go forward with the trial. Then COVID hit. Jury trials were suspended for the duration of the public health emergency. The Blankenship trial was reset for February 9, 2021, and subpoenas issued in December. Ms. O'Toole took office January 3, 2021. A motion to continue was filed by the state on January 7, 2021. On March 12, 2021, Kelsey Blankenship accepted a plea offer and was sentenced to serve 6 years in prison, as agreed by the state and defense. So finally, she was available to testify against Joshua Gurdo. To be clear, it wasn't as if nothing was happening in the Gurdo case from 2018 to 2021. There were over 40 motions filed by the defense in the murder case alone. The court met regularly with the state and defense to discuss the status of those motions and determine what could be stipulated to and what needed to have a formal hearing. There was additional investigation done by law enforcement and additional discovery provided to the defense by the state that then had to be reviewed. And again, COVID hit. All jury trials were continued for the duration of the health emergency. Despite COVID, perhaps the most important event to take place during this time frame was that Joshua Gurdo was indicted in December 2020 for an unrelated aggravated burglary, rape, and felonious assault for offenses that occurred in December 2004. After the indictment, a hearing on all pending motions was set for March 17, 2021, shortly after Kelsey Blankenship's guilty plea and sentence. The trial was scheduled for May 4, 2021. Colleen O'Toole took office January 3, 2021. When she says her office never filed for a continuance, she is correct, but she is not telling the whole story. On March 22, 2021, with the agreement of the state and the defense, the trial set in May was continued. While she may not have filed the motion to continue, Ms. O'Toole agreed to it. The reason for the joint continuance was that the parties were trying to resolve both of Mr. Gurdo's pending cases, the murder and the aggravated burglary. There were also several motions the defense in the aggravated burglary case intended to file. The defense in the murder case also wanted time to get a copy of the transcript of the court proceedings where Kelsey Blankenship pled guilty to her involvement in this case. So Gurdo's trials were rescheduled for August 24, 2021. On July 28, 2021, Gurdo's attorneys filed for a continuance. The state filed a written response stating that they did not object to the continuance. The defendant's motion for continuance was granted on August 9, 2021, and the trial was reset for October 29, 2021. On October 4, 2021, the court received a copy of the proposed plea agreement we have all read so much about. The court ordered the parties to file written briefs arguing to the court why the plea should be accepted. A hearing on the plea and all pending motions was set for October 14, 2021. We don't know what was said in the written brief or in the hearing before Judge Cezanne because Ms. O'Toole filed a motion to seal the briefs and the hearing so the public could not hear what the plea offer was or her reasons for the offer. All we know for sure is that on October 19, 2021, the court rejected the proposed plea. The case remained set for trial on October 29, 2021. Then the defendant was diagnosed with COVID. In the meantime, the state filed a motion in the Supreme Court of Ohio to recuse Judge Cezanne from the case. In January 2022, Judge Cezanne voluntarily recused herself from the case. Shortly thereafter, the other two Ashtabula Common Pleas General Division judges recused themselves as well. The Ohio Supreme Court appointed Patricia Cosgrove to preside over the Gerdo cases on February 25, 2022, and the jury trial was set for May 16, 2022. The state elected to try Gerdo's newest indictment for rape and aggravated burglary first. So it was called for trial, and Gerdo pled guilty. He was sentenced to 28 years in prison. He filed a notice of appeal on May 24, 2022. Gerdo's murder trial is now set for October 3, 2022. According to the court's public docket, the state has not subpoenaed any witnesses yet. They have, however, filed a motion to amend the indictment, as we all heard from Ms. O'Toole. The next hearing, as listed on the public docket, is a final pretrial set for September 23, 2022. Just so everyone knows and can look for themselves, everything I have said so far can either be found in news media reports or on the Clerk of Court's public docket for each case. I have no access to the prosecutor's file and have not used any information I may remember from that file for this letter. Ms. O'Toole talks about the rule of law, her oath to do justice in the Constitution of the United States. As if Mr. Iarocci and I ignored those oaths, the rule of law, and the Constitution. For many years we were at the Ashtabula County Prosecutor's Office, both of us first serving as assistant prosecutors and eventually as county prosecutors. How can we trust our current county prosecutor, who has never prosecuted a criminal case, let alone a murder case, to decide what the evidence in this case may or may not prove? Do we trust her staff to guide her? How can we, when all but 3 of her assistant prosecutors are new to Ashtabula County? I know it will be easy for Ms. O'Toole and her supporters to dismiss this as sour grapes. I hope all of you know me well enough by now to know better. I hope all of you realize the judges have controlled their dockets in pretty much the same manner since they took the bench, as did the judges who served before them. I served under 2 excellent county prosecutors and had the privilege of serving as county prosecutor for a short time myself. In that time, I prosecuted criminal cases before 5 different common pleas judges in Ashtabula County. Not once have I heard a county prosecutor blame their officers' failures on the Ashtabula Common Pleas judges. Until now. Sereniti and her family deserve to be treated better than this.
I couldn't agree more. In September of 2022, Ashtabula County Court records indicated that Joshua's trial was converted to a plea hearing. I reached out then to Sereniti's grandma, Melissa, who told me no one had contacted the family about any plea deal, which Judge Cosgrove had assured the family there would not be in this case. Well, she was technically right. There was no plea deal. On October 3, 2022, Judge Cosgrove, unthinkably, granted the prosecution's motion to amend Joshua's charges, which allowed him to plead guilty to a single charge of involuntary manslaughter. Before Joshua entered his plea, Colleen O'Toole told Judge Cosgrove that there was no evidence of rape in Sereniti's case, saying that the condition an emergency room doctor thought was evidence of rape was actually a severe diaper rash. She also claimed in the hearing that DNA from an unidentified male was found on Sereniti's body, although there's no word on where that DNA was found or what type of DNA it was. Judge Cosgrove then delivered Joshua's sentence, 8 years in prison, to be served consecutively to the 28-year term he was already serving. He got more time for his rape and burglary than he did for the murder of a baby. This depraved, incredibly dangerous man will only be in his 70s when he is released from prison, and that's the best-case scenario.
I cannot tell you how hard I took this news. I had to log off the internet completely for the rest of that day. I could not stop crying tears of anger and frustration and sadness that the prosecution and the judge valued Sereniti's life so little. Later that month, documents relating to the originally proposed plea deal were unsealed. At the hearing in October of 2021, during which Judge Cezanne rejected the plea deal, Ms. O'Toole claimed all of the victims in the case had agreed to the plea deal. Judge Cezanne requested a list of family members from the Victims of Crime Office wanting to speak with Sereniti's family for their thoughts on the plea deal, and prosecutors objected repeatedly to her requests. Ms. O'Toole said she worried that family members would be traumatized again by asking for their feelings about the plea agreement. What kind of bullshit is that? O'Toole fought hard to prevent Judge Cezanne from having those conversations or asking for opinions from family members who hadn't been identified specifically as victims through the prosecutor's office. She even fought against specific questions the judge wanted to ask the victims. For the record, Sereniti's family members were completely against the plea deal. After the plea deal information was unsealed, O'Toole said, "It's important that people can evaluate the facts of the case and the fact that Mr. Gurdo did not commit the rape." That statement, too, was disingenuous. We can't evaluate the facts of the case. We can only evaluate what she says are the facts. Without making Sereniti's autopsy report and other documentation public and providing proof that Joshua Gurdo did not rape and murder this innocent 1-year-old baby, Colleen O'Toole will not convince me or many others that he didn't deserve the original charges against him. The 43-year-old walking pile of excrement named Joshua Dale Gurdo is currently serving his sentence in the North Central Correctional Institution in Marion, Ohio. We can only hope he's not in protective custody and all of his fellow inmates take daily exception to his crimes. Now that I'm adequately riled up, let's take another sponsor break. In episode 24, I told you about Josias Marquez, a very special little boy with the sweetest giggle. As a newborn, Josias suffered from meningitis and spent the first several weeks of his life in the hospital. He survived, but he was left blind, suffered from seizures that required heavy sedation, was unable to walk, and required constant care. In January of 2020, Josias' older brother and younger sister showed up on a neighbor's doorstep in Howard, Wisconsin, saying their mommy had left them alone overnight and had not yet returned. Police and CPS began investigating the children's mother, Segal Hussein, and discovered she had a third child, 5-year-old Josias, who could not be located. Segal told police Josias was with his father in Michigan. It was later discovered that Josias' father was a different man named James Marquez, who lived in California and had no idea where his son was. Segal was arrested on March 30, 2020, due to inconsistencies in her story and her refusal to cooperate with investigators. Her vehicle was impounded and searched the following day, at which time Josias' mummified remains were found in a duffel bag in the trunk. Segal received multiple charges in relation to her son's death. After a year and a half, Segal accepted a plea agreement in October of 2021, pleading no contest to 5 charges: neglect of a child resulting in death, 2 counts of child neglect, moving or hiding the corpse of a child, and a single count of obstructing an officer. 5 other charges were dropped, including forgery, uttering, and 4 additional counts of obstruction. The plea agreement allowed both the defense and the prosecution to argue for what they believed was an appropriate sentence. A plea of no contest essentially means the defendant concedes that the court has enough evidence to find them guilty of the crime in question, but does not force them to admit guilt. Segal's sentencing hearing took place on December 7, 2021. She was sentenced to 15 years in prison, followed by 10 years of supervision. She is currently serving her sentence in the Taycheedah Correctional Institution in Fond du Lac, Wisconsin. She is expected to be released in March of 2035. I am at least happy to report that Josias' brother and sister seem to be doing very well and are being raised by their paternal grandma, Tina, who is an incredibly strong woman and an amazing mother and grandmother. Brother and sister Conner and Brinley Snyder were the subject of episode 29 of this podcast. Conner was a friendly, cheerful third grader who loved playing video games, building forts, and spending time with his younger sister Brinley and their older brother Owen. Brinley was a precious little girl with a sweet smile who loved playing dress-up and the movie Frozen. She had just started her second year of pre-kindergarten. On the afternoon of September 23, 2019, EMTs were summoned to the Snyder home in New Albany, Pennsylvania, where they found both 8-year-old Conner and 4-year-old Brinley hanging approximately 3 feet apart from a single wired dog cable lead, which was wrapped around the main support beam of the basement, and each end of the wire wrapped around the victims' necks. On September 26th, after 3 days on life support, Conner and Brinley died just 14 minutes apart. Prosecutors allege the supposed murder-suicide was actually a double murder perpetrated by Conner and Brinley's detestable mother, Lisa Snyder, who told police and anyone who would listen that Conner killed himself because he was bullied and took his sister with him because he was afraid to die alone. Police have found no one who can corroborate Lisa's stories that Conner was bullied, depressed, or suicidal. Lisa, who found her children hanging in the basement, did not attempt to cut them down or release them from the dog lead. When EMTs arrived, Lisa was outside smoking a cigarette. Evidence indicates Lisa planned the murder. Her Google records revealed that she searched hanging, carbon monoxide poisoning, and the TV show I Almost Got Away With It. Lisa Snyder was arrested on December 2, 2019, and has been held ever since at the Berks County Prison. Prosecutors have announced their intention to seek the death penalty. Lisa's attorneys intend to use an insanity defense. Lisa will face a separate trial for charges related to photos found in her Facebook Messenger of herself engaging in sexual assault on the family dog, who has since been adopted by another loving family. Since my last update on this case in November of 2021, in February of 2022, Lisa's attorneys sought to exclude from evidence both Lisa's internet search history and the statements she made to officials before her arrest. Judge Paul Yatron scheduled a May 25th evidentiary hearing to hear from prosecution witnesses who would testify about the issues raised in the defense's motion to suppress. That hearing was pushed back to July 25th. I spent entirely too long trying to find out what happened to that motion, and I'm incredibly frustrated to tell you I couldn't find what I was looking for. On October 7, 2022, Judge Yatron issued an order on the motion, in part granting it and in part denying it, although there are no details on which parts were granted or denied. No news outlets covered this development either. Sadly, on December 6, 2022, Judge Paul Yatron passed away at age 71 after nearly 17 years on the bench, during which he heard an estimated 20,000 criminal cases. Berks County President Judge Thomas G. Parisi said of Judge Yatron, "This is a tremendous loss for our legal community and to all citizens of Berks County. He treated all litigants with dignity and respect. On behalf of the court, we offer our deepest condolences to family, friends, and colleagues of Judge Yatron." After the judge's death, Lisa's case was reassigned to President Judge M. Teresa Johnson. Lisa's next court date is a disposition hearing scheduled for February 21, 2023. In the meantime, she is still being held in Berks County Prison as she awaits her 2 separate trials, neither of which has been scheduled yet. Time for one last quick sponsor break. The last update today is on the case of Arabella Parker, whose story I told in episodes 16 and 17 and updated just last week. The same day episode 132 came out, this disappointing news broke. I won't go into the backstory again since I did that last week, other than to say that Arabella was 3 years old when she died in 2019 at the hands of her mother's boyfriend, Jared Burgess. Jared, his mother Christy Willis, and Arabella's mother, Samantha Delcamp, were all convicted of various charges in relation to Arabella's death. Arabella died from irreversible brain damage, largely because Jared and Samantha delayed seeking medical assistance for her for almost an hour while they tried to get their story straight with Jared's mother, a nurse who wasn't even there when Jared admittedly threw the 3-year-old across the room. Arabella's adult half-sister, Amanda, provided testimony at Jared's trial and has been a big part of Arabella's story all along. That's why I'm especially disappointed to tell you that on Wednesday, February 8, 2023, 24-year-old Amanda Lynn Parker was arrested and charged with a felony count of endangering the welfare of children. She is accused of providing inaccurate information and being purposefully dishonest with medical staff at Evangelical Community Hospital in Lewisburg, Pennsylvania, in regard to her own daughter's head injury. According to a probable cause affidavit, on January 26th, medical staff contacted police, informing Watsontown Patrolman David Podgorny that Amanda's 6-month-old daughter was in critical condition due to a skull fracture and was about to be airlifted to Geisinger Medical Center in Danville, which is the hospital where Arabella died. Amanda told hospital staff that her baby girl hit her head while sitting in her bouncy seat, and despite the baby's head swelling at the injury site, she dropped the baby off with her babysitter at 9 a.m. anyway. Police interviewed the babysitter, Jasmine Norman of West Milton, who initially told Officer Podgorny that she noticed the baby's swelling worsening, took her to the hospital, and then informed Amanda what was going on. When confronted about the statement being inaccurate, the babysitter admitted that, in fact, Amanda asked her to take the baby to the hospital so Amanda wouldn't get in trouble. Text messages showed the two women talking about lying to medical staff about the baby's injury. Jasmine told police that on the afternoon of January 26th, Amanda called her and asked her to take the baby to the hospital. When she arrived at Amanda's house, both Amanda and the father of both of her children, 36-year-old Ernest Reynolds III, were there. Jasmine said that when she arrived, Ernest left for work despite his younger daughter's condition. The affidavit stated that Amanda and Jasmine's statements contradicted, and that in text messages, Amanda told Jasmine that the baby fell off a bed, but "She is fine. I had her checked." However, representatives from Children and Youth Services, or CYS, told Officer Podgorny that the baby had missed several scheduled pediatrician appointments, and Amanda apparently later told Jasmine she hadn't taken the baby for medical treatment for her head injury. Ernest Reynolds III is also being charged with felony child endangerment. He has not yet been apprehended, and investigators are searching for his whereabouts. Anyone who has information can contact the Watsontown Police Department at 570-538-2773 or the Central Susquehanna Regional 911 Center at 570-742-8771. Amanda was arraigned on February 8th. She is currently being held in the Northumberland County Jail on a bond of $75,000. Again, I'll be working on additional update episodes in the coming weeks, although I don't plan to release them back-to-back. My sources for the updates in this episode were the Shaw Local News Network, the Illinois Department of Corrections website, 7 News WWNY, the Watertown Daily Times, the Ashtabula Gazette, the Ohio Department of Corrections website, the Wisconsin Department of Corrections website, the Morning Call, 69 News WFMZ, Lamb and Whitman Funeral Home, the News Item, PA Homepage, the Daily Item, Instant Checkmate, and VineLink. That's it for this week. Join me next week for another episode. If you like the show, please follow or subscribe to Suffer the Little Children on Apple Podcasts, Google Podcasts, YouTube, Spotify, Spreaker, Pandora, iHeartRadio, Stitcher, or your favorite podcast listening app. And please leave me a 5-star rating and a positive review on your favorite podcast platform. Visit the website at sufferthelittlechildrenpod.com. You can support the show by visiting patreon.com/stlcpod, where you can become a patron for rewards ranging from a shout-out by name on the show to bonus content and exclusive gifts. You can also support the show at ko-fi.com/stlcpod. Follow the podcast on Facebook and Instagram at Suffer the Little Children Pod and on TikTok at STLCpod. View photos related to today's episode on Facebook. For more stories like the one you heard today, visit sufferthelittlechildrenblog.com. This podcast is researched, written, hosted, edited, and produced by Laine. Intro theme music is by Dream Note Music. and all music for the show is licensed from audiojungle.net. For more information about preventing or reporting child abuse, visit childhelp.org or call your area's child abuse hotline. And remember, if you see something, say something.